Yes, Mr. Hutton.
Yes, my lords, my lady, dealing with the issue of CADA and whether what the Court of Appeal was saying was that the Section 3A fixed cost regime was disapplied retrospectively or just prospectively. Just on that point, it's never been, this doesn't mean that the court can't decide whatever it wants to decide. Of course it can. But it's never been the defendant's case that CADA only applied prospectively to costs after that date. And indeed, this was the subject of decision by Judge Dudridge, again, obviously not binding on this court. But can I take your lordship to the passage in his judgment at page 161 in the bundle, tab 12. And paragraphs 14 and 15, where he dealt with this point head on. Because he says at 14, I'm bound to say that it seems to me that if one reads the rule without recourse to the judgment of Lord Justice Briggs, it is at least very ambiguous in that it is not clear whether the words "and for so long as the claim is not allocated to the multi-track" are intended to mean that fixed costs no longer apply from the date of allocation, or that they no longer apply at all with allocation to multi-track, etc. However, it is clear from reading the judgment as a whole that Lord Justice Briggs was deciding that the fixed cost regime was not intended to apply at all to cases that ended up allocated to the multi-track. So it did have retrospective effect. Now that's how the case has proceeded thus far, and it's not been part of my friend's argument that Judge Dudridge was wrong about that. Can I then just come back to CADA itself? Obviously, the court will take their own view, and I accept there is no knockout blow for my case in CADA. But in my submission, His Honour Judge Dudridge's interpretation was correct. Can I just rely on a few paragraphs in that regard?
Just help me on this before we go into it. CADA was discussing the rules as they were.
Yes.
And decided that there was a drafting error.
Yes.
The drafting error was then rectified by the Rules Committee.
Yes.
It is true that the Rules Committee used, as far as I can see, the same words that Lord Justice Briggs thought should be inserted.
Yes.
What is the status of CADA as regards the amended rules? Are we simply construing the rules as they now are? Are we bound by CADA insofar as we construe the rules? Is it persuasive authority? Is there some version of the Barras principle where the Rules Committee must be taken to have accepted whatever Lord Justice Briggs thought was the intended effect of the rules?
Yes.
How do we deal with
CADA? My lord, CADA deals with the legislative intention, and as I said, in Mrs. Justice Stacey's words, does the heavy lifting for you in that regard. So you know what the intention was, unless you disagree with what Lord Justice Briggs says. The legislative intention was clear. It should never, the fixed cost regime should never apply to a case allocated to the multi-track. And the suggested rule by Lord Justice, by the Court of Appeal, by this court in CADA, was to give effect to that legislative intention. And so in that regard, you have to have those words with this court's interpretation of the legislative intention behind it, because those words were to reflect the legislative intention that had never made it in the rule. So in that regard, in my submission, it would be binding on this court.
Right.
But I accept that it's a relatively unusual situation because the Inco-Europe jurisdiction is quite rarely used. If one looks at paragraph 35 on page 319. And it's a similar point to the point I made in relation to 59. The conclusion is, after more hesitation than Lord Justices Grace and Tomlinson, is that the rule should be read as if fixed cost regime which it prescribes start in the RTA protocol but no longer continue under it, is automatically disapplied in any case allocated to the multi-track. Now, if it's disapplied, and I agree, there's a danger of reading this as a statute, and it's not a statute. It's a judgment. But if it's automatically disapplied in any case allocated to the multi-track, it's the case that it's disapplied from. And then he goes on to say, without the requirement for the claimant to have recourse to 4529J, the exceptional circumstances point. And I make the same point that I made earlier in relation to paragraph 59. If he was saying that the fixed cost regime applied up to that point, then you may have need for recourse for 4529J in relation to the costs up to that point. So we say that is then consistent with 35D at the bottom of that page. The last line on that page and the first on the next page demonstrate that it was not in fact the intention of those legislation for this regime that it should ever apply to a case allocated to the multi-track. So it's not applying to the case generally. And if one then goes on to paragraph 49, this is the quote from the Ministry of Justice's response to the consultation. Paragraph 87 of that response stated as follows. Respondents were unclear whether the proposals are to apply to multi-track as well as fast-track cases. There was a clear view that any proposal should apply only to fast-track cases. It has always been the government's intention that these proposals apply only to cases in the fast-track, and that if a case falling out of the protocols is judicially determined to be suitable for the multi-track, normal multi-track costs rules will apply. Now, this case was never allocated to the fast-track. The only allocation it received was to the multi-track. And the intention was that the proposal should only apply to fast-track cases. And this was never a fast-track case.
But there's always a stage before a case is allocated to any track.
There is, yes, yes.
What they then deal with in 55.
Yeah, I'll come on to that. Yes, 55, absolutely. And I'll come on to the Ho point and what Lord Justice Newey says, because we say that's actually a slightly different point. That is reallocation from the fast track to the multi-track. And there's a different rule in relation to that, which I'll come to. Yes, in relation to the period before allocation, the general rule as we understand it is that once a case is allocated first off to a track, it becomes that track generally. It doesn't, because it hasn't been allocated to any track before then, it is always a multi-track case if it's been allocated to a multi-track case. And we've been trying to find the rule, but helpfully it's set out, albeit I accept in relation to small claims in the fast track. It's at paragraph 50 of my learned friend's skeleton, which he helpfully pointed me to. It's CPR, it was the then CPR 4611.2. It's
paragraph 50.
Paragraph 50 of his skeleton on page 30 of the report bundle. And he quotes from 4611.2, across on the small claimant track and the fast track. So this is in the context of costs specifically, because CPR 46 is a cost rule. Once the claim is allocated to a particular track, those special rules shall apply to the period before as well as after allocation, except where the court or practice direction provides otherwise.
And does a particular track include the multi-track in this rule?
Well, it doesn't say so, and we couldn't find an equivalent for the multi-track. but there's no rule suggesting that the multi-track is different, but there is an absence. But that's the general principle. The difference, we say, is in relation to reallocation. So when you've been allocated to a track and then you reallocate, because that brings in the Ho case, and that was the context in which Ho was decided. So, so Ho is at tab 21, and at paragraph 21 on page 389 of the authorities bundle, it says, Lord Justice Newey says, under CPR 26.10, a claim allocated to one track may subsequently be reallocated to a different one. In that event, CPR 46.13 is in point. That provides at subparagraph 2, where a case is allocated to a track and the court subsequently reallocates that claim to a different track, then unless the court orders otherwise, any special rules about cost applying to the fast track will apply up to the claim up to the date of reallocation. To the second track will apply from the date of reallocation. So in other words, there is a distinction between 46.11, which I've just quoted from paragraph 50 of Malone and Friends Skeleton, which says that allocation, once you're allocated, it works retrospectively as well as prospectively. But if you are allocated to a track and then the court reallocates, then the default position is that you get the old costs up to the date of reallocation and the new cost regime thereafter. And that was the context of Ho and Adelahan, because the question in that case, the point raised by Mr. Malilieu in that case was that the case that the claimant had applied for reallocation, paragraph 23 on page 390, and it was Mr. Malone from Mr. Roy and Mr. Malilieu, sought to argue that the respondent solicitor's response to the letter represented a counteroffer, etc. At the end of paragraph 23, the claim ought, he said, Mr. Malilieu said, to have been reallocated to the multi-track with an order applying the cost rules applicable to that track retrospectively. So that's the 46.13 point. And two issues arose. One, whether the offer letter was to pay conventional costs, etc. And in relation to that, we then see at paragraph 33 the passage that Lord Justice Miles pointed out. As I have mentioned, this is on page 394, I have mentioned Mr. Malilieu also relied upon the fact that CPR 4529B provided for fixed cost regime to apply for as long as the case is not allocated to the multi-track, and suggested in consequence the regime would automatically cease to apply from the start on reallocation. Reallocation, note those words. This, however, is far from obvious. The more natural interpretation of 4529B might be thought to be that where a case is transferred from the fast track to the multi-track, the fixed cost regime ceases to apply prospectively, not in relation to past costs incurred when the case was in the fast track. So just pausing there, that's the situation covered by 46.13, where the default position is that the previous cost regime applies up to that date. Then going on, nor as I see it does CADA, where the insertion of the words for so long as the claim is not allocated to the multi-track was suggested, lend any support to Mr. Malilieu's contention. The CADA case did not concern a situation in which a claim was transferred to the multi-track from the fast track. Now, we are not in a position of reallocation from the fast track to the multi-track.
But it does mean that you can't take CADA to lay down some blanket rule that whenever a case is allocated to the multi-track, fixed costs disappear completely.
I have to accept that.
So there's
if-
some qualification, whatever it is,
Yes,
has to be read into CADA and by extrapolation into the rules as they now are, having adopted the phraseology that Lord Justice Briggs suggested.
yes, I accept that on the basis that 4613 provides the default rule, which would suggest that you get the fast track costs up
Yeah.
to the date of
And what Lord
reallocation.
Justice Newey is essentially saying is that 4529B doesn't override that.
No, I accept that, but he's not going any further than that. He's not laying down a general principle that in CADA they were saying it wasn't retrospective. They were saying it only applies prospective.
Well, he was saying, wasn't he, that 4529B isn't incompatible with that reasoning.
Yes. No, I accept when another rule provides a default position. Yes, I accept that. I accept that. We say that's very different to our position because another rule doesn't so provide. And I suppose that then raises
that
the
really
question of
helpful?
3620 and whether that rule so
Yeah.
provides.
Right.
Yes. But I mean, my lords, my lady, our submission is that His Honour Judge Doddridge was correct in his interpretation, and indeed the note in the white book that I took your
Yeah.
lordship's earlier, lordship and ladyship earlier, what is correct in that regard, and it, you know, this court has the power to do what it feels is right, but it would be a surprise to the profession if in a case allocated to the multi-strat that was an RTA protocol case, they're supposed to be drawing up bills on the fixed cost regime up to that date and thereafter. Now that's not in any way binding on
I think
this
the
court.
profession,
But
I think the profession has had its share of surprises.
yes, I accept that. I accept that. But it's certainly not the way it's been interpreted to date.
I mean, Judge Doddridge seemed, just since you've referred to him,
Yes.
he makes that general point about whether it's retrospective or not, which may be it may be actually quite an elusive concept here, because he then goes on later on to say, but CADA doesn't deal with the situation we're dealing with. And as I
Yes.
see it, his essential reasoning is really in paragraph 40, where he says,
Yes.
what we're dealing with is CPR 3620,
Yes.
which does apply. And he says that CADA doesn't override that effectively.
Yes. Yes.
Or nothing in CADA leads one to read that in a different way. That's what I understand him to be saying.
Yes, I accept that. And he's saying that CADA is, as he says, is not necessarily directly binding on him.
I mean, he says at the end of, the way he puts it at the end of 39 is, does CADA have the effect of retrospectively taking the case out of the fixed cost regime for all purposes? So he
Yes.
seems to be saying, if it was a CADA type case where all you're asking is, well, the case is going to trial, which cost regime is going to apply, then it does operate retrospectively. But his reasoning seems to be that it doesn't follow from that when you read other rules, is to be treated as being retrospective for all purposes.
Yes. Yes, I accept that. And that then leads us on, I suppose, to looking at CPR 36. So can I come on to that? So it starts at it's tab 1, the authorities bundle. And it's the 3613. So as I understand how it works is if one goes back to 36.5, which is at page 9 in the authorities bundle. it makes clear Part 36 offer must specify a period not less than 21 days, which the defendant will be liable for the claimant's costs in accordance with Rule 3613 or 3620 if the offer is accepted. So those are the two different routes for the cost regime to apply if the offer is accepted. And at 3613, it says at page 16, subparagraph 1, subjects to paragraphs 2 and 4 and to Rule 3620, where a Part 36 offer is accepted within the relevant period, claimant will be entitled to his costs of the proceedings up to the date on which notice was served. Then gives an explanation for 3620, and then at subparagraph 3, it says, except where the recoverable costs are fixed by these rules, costs under paragraphs 1 and 2 are to be assessed on the standard basis if the amount of costs is not agreed. So the first question is, does this come within 3613 or does it come within 3620? And we say in a case which has been allocated to the multi-track, the effect of CADA and CPR 4529B is that the costs are not fixed. So you never go further than CPR 3613.3 because your costs are not fixed by the rules. It's as simple as that, and therefore standard
There's a
basis
bit of
costs
sleight of
apply.
hand now because, as I put to you earlier, it might be 3620 which fixes the costs.
Yes, certainly, yes, I accept that. But, well, my submission is that what fixes the costs in an ex-RTA protocol case is CPR section 3A of 45. That's what fixes the costs. And then all 3620 does is applies those rules to the Part 36 position.
What should take a case like this one where it started under the protocol, it exited the protocol, proceedings are started, they haven't yet been allocated, and the defendant wants to make a Part 36 offer.
Yes.
Go back to 36.5.
Yes.
So Rule 1, paragraph C. Specify a period of not less than 21 days within which the defendant will be liable for the claimant's costs in accordance with Rule 3613 or 3620 if the offer is accepted. Does the defendant have to choose between those, or is the defendant prohibited from choosing between those? Because the consequences will differ on your argument
Yes.
according to whether the offer is accepted while the claim is still unallocated,
Yes.
and after it's been allocated, if allocated to the multi-track.
Yes.
So
Yes.
what's the offer supposed to say?
I accept that that is a difficult question because you could, I mean, according to the rule, you have to say will be liable in accordance with either rule. I suppose you could say either rule. You could cite both of those rules. There's nothing wrong with that.
Yeah.
In a situation where it might be allocated to the multi-track and therefore 3620.
That's probably what on your construction, what the defendant has to do.
Yes, I accept that. I mean, I wouldn't submit that if you cite the wrong rule there and you say 3620 rather than 3613, that makes it an invalid Part 36 offer. Because
You
ultimately,
actually have to specify either rule. Or can you just say the period is, this is a Part 36 offer
yes,
and it's made under, and the period is 21 days.
yes, you could, and then I mean, so your Lordship will be interpreting that is in accordance with Rule 3613 or 3620 is not a requirement to state. It's just That's the consequence of the rule. It is either. Yes, I accept that.
I mean, going back to your argument about 3613, and because you say there are no fixed costs, and therefore
Yes.
the default rule applies. The bit you're relying on in 3, except where the recoverable costs are fixed by these rules,
Yes.
there's first of all the point that my Lord Justice Lewison has made, that it may be the costs are just fixed under Rule 20, but leave that to one side.
Yes.
The other point is that it then goes on to say costs under paragraphs 1 and 2 are assessed on a standard basis. But you only get onto 1 and 2 if it's not within 3620, because that's an exception to
Yes.
3613 in the first line.
Yeah.
Because this is all subject to 3620.
Yes.
So don't you have to start the other way round and ask whether the case is within 3620 to begin with?
Yes. So if that is done, and we go to 3620, then the heading of 3620 is cost consequences of acceptance of a Part 36 offer, where Section 3A of Part 45 applies. Now, pausing there, we say that is the whole of Section 3A. It's not limited to 4529A. That has got to be read as including 4529B as well, because it's where Section 3A applies. And I accept in principle Section 3A applies, subject obviously to my earlier argument. Well, if you come within 4529B because you've been allocated to the multi-track, are you disapplied from Section 3A or just from the fixed cost regime? Strictly just from the fixed cost regime. So Section 3A applies. So you have to interpret 3620 in the light of the fact that that includes 4529B, which says that if you're allocated to the multi-track, you are not fixed costs. And that in essence is our argument that 3620 has to be interpreted in the light of the legislative intention as found by this court in CADA, namely in a case allocated to the multi-track, fixed costs cannot apply. Simple as that. And in answer to your lordship, Lord Justice Miles' question earlier, which on 3620 is, well, what happens if the case has already been allocated to the multi-track, ex-protocol case already allocated to the multi-track, and then the offer is made? Why don't you come within 3620? My learned friend's answer was, well, you don't because of the temporal issue. But in my submission, there's no suggestion that there's a temporal issue or that it's to be decided as at the date that the 21-day period expired. That's not in the rule. The question is whether fixed costs apply. Well, fixed costs don't apply, we say, for the reasons I've said. So that the temporal interpretation that you have to look at the position at the end of the 21-day period is absent from either 3613 or from 3620. And my learned friend relies on the fact, well, if you then accept the offer, you're entitled to your fixed costs at the stage at which you settle. So CPR 36, 4 and 5. But of course, you're only entitled to your fixed costs up until that date. It's just specifying that if you settle your case and you're entitled to your costs at that date, you don't get fixed costs beyond that date. You don't get the fixed costs of the trial or anything of that sort. So all that is doing is applying Section 3A, and that's all that 3620 is seeking to do, which is explained by the heading. It's where Section 3A applies. And you can't pick and choose 3A and say, well, we'll rely on 4929A, but not 4929B as amended by CADA, or as amended consequential on CADA. So I accept, and Mrs. Justice Stacey accepted, that it perhaps would have been happier if 3620 had been qualified specifically by the CADA amendment. But in principle, it would completely, I suppose the question has to be asked, why shouldn't 4529B and the legislative intention as found in CADA apply in Part 36 cases? What is the reason for accepting Part 36 from the general principle that if you're allocated to the multi-track, it's a suitable case for the multi-track, the court's found it's multi-track, therefore you're entitled to the costs of the multi-track? Why, what would be the reason for accepting it in Part 36 cases, but applying it otherwise? I ask rhetorically.
To encourage early settlement might be one answer.
Well,
before the costs rack up when you've been allocated to the multi-track.
yes, but nevertheless, you know, there is a consequence for accepting late. The consequence is, firstly, you don't recover your costs from the date 21 days afterwards. The second consequence normally is you'd have to pay the defendant's costs from 21 days afterwards.
You don't with Quox.
You don't with Quox.
Well, you didn't with Quox.
You didn't with Quox. That has changed, exactly. Yeah. So there is a consequence in accepting late. But we go back to the point made by Lord Justice Miles earlier. If it's a multi-track case, if it's got 6 experts, if it's got, you know, much more than £25,000, then the right costs are not those fixed costs, and that's what CADA says. They were never designed for such a case. And it is, of course, happenstance as to when the case is allocated. It happens to have been that it was allocated a long time afterwards. But that is happenstance, that the defendant will get, whether you call it a windfall or a bonus, for paying fixed costs in relation to a case which was suitable for the multi-track and should have had multi-track costs.
Yeah.
And my lord, if one goes to the judgment below of Mrs. Justice Stacey at tab 9 in the court bundle, and it's paragraphs 74 and 75 on page 126. And that we say is the heart of it, and that the learned judge was right about those points. And at the end of paragraph 75, she held this: however, since the effect of 4529B is to disapply the fixed cost regime where an ex protocol case has been allocated to the multi-track, section 3A of part 45 does not apply. It is therefore an exception to an exception and falls to be assessed under the principle in 3613. And we say that the idea that the temporal point, which was not argued before Mrs. Justice Stacey, the argument by the defendant before Mrs. Justice Stacey, and that's the reason why she doesn't deal with the temporal point. The argument was, well, 3620 is clear that it applies to any ex protocol case at all, and therefore, if you're an ex protocol case, you're caught by the fixed cost regime pursuant to 3620. And so in answer to So the court's question at that stage, well, that would apply to any case when, so it might have been allocated already or whatever. Learner friend's answer was, well, that is the consequence. So the question now is, having modified the case to say, well, he's relying on a temporal issue, namely, you look at the position as to the cost regime that applied at the end of the 21-day period. There is no authority in support of that notion. And we say it's contrary to 3613, which says that the fixed costs don't apply because as at the date you're looking at it, as of the date of settlement, it was a case where fixed costs didn't apply because it had been allocated to the multi-track in the meantime. Yeah. And that we say is a novel point that one should somehow backdate it to that point. And as we say, there's no authority to support it.
Well, sometimes we're in the business of creating authority.
Well, I entirely accept and defer to your lordships as to that. I could go on longer, but I think the court has my points, and essentially it is in support of the judgment of Mrs. Justice Stacey. I ought to deal with the Williams point. I don't know how much you require from me on the Williams point. That's ground.
This is ground two. I think you can take it shortly. I'm
grateful. So essentially, what we say in relation to Williams is, and it was a case in which your lordship and myself were involved. Your lordship has no memory of it. I have a little memory, but that's the nature of being an advocate rather than a judge who sees cases every day. But essentially, I can take the court to it if necessary, but throughout, it is based on a finding that in a case where if you had two defendants, you were outside the protocol. They said they had two defendants, but that was unreasonable. The only reason they had two defendants was because the claimant hadn't provided the information.
The basis of Williams is that the case should have proceeded under the protocol.
Yes.
Here, as you said in opening, your client is getting no more than the costs attributable to the kind of case which she had.
Precisely. And there's no finding of unreasonable conduct on our part. There was in Williams. It was an unreasonable action. There was no finding. It's just because we accept a Part 36 offer late has cost consequences, but it doesn't necessarily mean that we've acted unreasonably. The case may change in the meantime, etc. All those points Mrs. Justice Stacey accepted. So we're not in that category. The question is then, as your lordship's question kind of hinted at, are we in O'Byrne territory where before there was a rule dealing with this point in O'Byrne, it was obviously going to be a small claims track case, but there was no rule that says before it's allocated, so the court approached it on the basis, well, it was obviously going to be a small claims track, therefore we're going to apply the small claims track costs.
In your cases, it's the converse.
Exactly.
This was always going to be a multi-track case, assuming it fought.
Exactly.
Yeah.
I think the court has my point. Yes. I think those are my submissions. Thank you very much.
Thank you very much. Mr. Roy, do you wish to reply?
I do, if I may, yes.
Yes, of course.
All on ground one. I'm not going to push further on ground two. The bad news is I think I've got 8 points. The good news is they are short. My Lord Justice Lewison put to Mr. Hutton that Cato does not mention Part 36 once, and Mr. Hutton agreed. We have 3 decisions of this court: Solomon, Rogers, Hislop. All 3 of those directly consider the relationship between Part 36 and Part 45, and they support my submissions. My second point in reply, again, in response to my Lord Justice Lewison, Mr. Hutton accepted, by reference to whom, that KDR does not impose an absolute blanket requirement that multi-track equals no fixed cost in all circumstances. I simply say that's a very important concession because that undermines the main plank of his case. Point 3, in reference to CPR 3620, Mr. Hutton said a couple of times that it should have been revised to reflect CADR. It actually goes beyond that, because we know from CADR, Part 45 should have excluded the multi-track from the outset. So in fact, 3620 should have, Mr. Hutton's argument said from 2013, which is 3610A, some proviso in respect of the multi-track. So Mr. Hutton's argument, there was an original error of drafting, missed 4 times since. Could I juxtapose that with page, I beg your pardon, I think I've got the wrong page, so bear with me. Sorry, if the court can bear with me, I have lost it. Oh, sorry. So I meant generally, I meant the page reference rather than generally. Page 437.
Of the authorities?
Yes, please. Just above that page, this is Benyon presumption 11.32. The presumption that legislation has been competently drafted. Not necessarily perfectly, but competently, and my learned friend submission is incompatible with that. Point 4, my Lady Justice Falk suggested that the wording 45.29b, as long as, should in fact read, unless allocated to the multi-track, and Mr. Hutton agreed.
Well, I think that was her ladyship paraphrasing Mr. Hutton's argument rather than
Very well.
her own suggestion.
If I misheard that, so be it. If I haven't, the simple point here is that, subject to that, to my hearing that correctly, Mr. Hutton's argument involves rewriting both 3620 and 45.29b, so both the key provisions. That's a stretch. Point 5 is in reference to 4611, which is found core bundle page 30, paragraph 50 within my skeleton. So once a claim is allocated to a track, those special rules shall apply to the period before as well as after allocation, except where the court for practice direction provides otherwise. I say that points in the other direction. The claimant's argument is that 4529b implicitly disapplies the rules retrospectively for all purposes. Well, if that type of thing happened automatically without the rules spelling it out, there'd be no reason for 4611 to spell it out. It would be OTOs to a degree. Point 6, my Lady Falk referred to the optionality, I think was her ladyship's word, the claimant doesn't have to accept a Part 36 offer. I simply observe that proposition is supported by the Supreme Court, still on the same page of the core bundle. It's citation we don't need to go to beyond what's set out in my skeleton. Bottom of page 13 to page 31, Lord Clark and Summers and Fairclough Holmes. The complaint here was in the context of striking out fraudulent claims and abusive process. One of the points raised by the defendant was, well, we can't make a Part 36 offer because a Part 36 offer means you've got to pay all the costs, and that would be unfair in a fraudulent case. And I'm paraphrasing very crudely, but Lord Clark said that's what makes them make a different type of offer. Nobody's forcing you to sell under Part 36. Point 7, as point emphasised a few times, Mr. Hutton says, well, look, this was a 6-expert case. It was always going to be allocated the multi-track. Certainly that was clear whenever our Part 36 offer was made. I accept that as a matter of fact, but we need to look at how any interpretation would play out across other cases. So I'm just like to shift the facts slightly and see where that leaves us, if I may. Let us suppose that at the time when we made our offer, and at the time when the offer expired, this remained a simple fast-track case, 1 expert. Obviously, if the offer had been accepted, fixed costs, no question that exceptional circumstances, it cannot be said that the claimant's getting no less cost than they're entitled to. So that hypothesis, the only thing that moves into the multi-track is the claim gets much bigger after the offer should have been accepted. On Mr. Hutton's analysis, this post-expiry contingency, which had no relevance to what the cost should have been at the time of expiry, would take him into conventional costs. In my submission, that simply can't be right. It tracks back to the point that I made originally that the function of a Part 36 offer is to shift contingency risks onto the offeree. That'll be another example of why Mr. Hutton's interpretation incorrectly shifts those risks onto the offeror, or at least ensures they remain with the offeror. And so, subject to instructions, which I'll check in with my 8th and final point, is maybe a counter jury point, or countering my learned friend's jury point. It was said the profession might be some professional surprise at certain results. I'd suggest, for what it's worth, there'd be quite a lot of professional surprise at the proposition that you get higher costs for accepting an offer late than in time. But as I suspect this court's not going to be swayed either way by jury points, but if it's about jury points, that is my one. Could the court give me a moment just to check? Unless I can assist further with my submissions and reply.
Thank you very much. Well, clearly this is an important point. It seems to be perpetuated in the current rules, and we will have to think about the answer. So we will reserve our judgments. You will get drafts in the usual way. They are embargoed, can be distributed only to those on the distribution list. That will be your chance to correct our English, but not our reasoning, and not to introduce new points. We would hope that in the light of the draft judgments, you will be able to agree a formal order disposing of the appeal. If you can't agree a formal order, please make short written submissions, and we will make the form of order that we consider appropriate. The eventual hand down will be electronic by release to the parties and to the National Archives. Thank you very much.
All rise in favour.